Browne Jacobson. I love the stuff. So I specialise in regulatory and criminal law with a particular focus on the health and care sector. Our clients include care providers, both independent and NHS, investors, so people who are investing in health and care sector businesses otherwise, and then companies that require proactive or regulatory litigation, advice from supported bodies. Carl has advised and represented national and local regulators, including HSE, CQC, National Union, local authorities, and fire authorities. But before you start, this is what I did last time. I'm going to introduce Jeff as well, because then I can sit down and pipe down. So I think most people know Jeff, Dr. Geoffrey Well, who's Technical Director at Foyle. Jeff started his career as a solicitor, became an equity partner at BLA, acting for insurers, professionals, public bodies, healthcare providers. Litigation practice included occupational disease, abuse and education-related claims. After leaving commercial practice, Jeff started teaching law and legal practice in higher education, obtained his teaching qualification, completed his doctorate concerning the regulation of medical decision-making in a reproductive healthcare context.
Fetal medicine.
Yeah, there you go. And as well as being our technical director for senior lecturer in law at the University of Chichester. So we'll hear from Carl, and then we'll hear from Jeff, and then there's a Q&A section, I think, at the end if we've got time. Carl, thank you.
Just quickly, so I'm not looking at my phone, but I am making sure I don't talk to you for hours. Right. Okay. So, yeah, thank you very much for the introduction. I think one of the other things, in terms of some of the clients and some of the work I've done, as I said, I've done work many moons ago representing CQC, their enforcement side of things, but also I sit on an NHS Trust Institute Candour working group, so discussing kind of implementation, monitoring, auditing, and policy around duty of candour for a particular NHS trust. So hopefully that gives me a little bit of an insight from various different angles in terms of apologies and duties of candour. So the duties of candour in healthcare are unique, I think, in the UK, whereby they focus particularly on candour towards the end user, towards the patient in this particular case. I looked around at whether there are any kind of equivalents, and I suppose the closest you get would be directors in certain circumstances, particularly around insolvency. There are particular transparency duties, but again, they're quite limited by certain circumstances and certain types of things that you've got to be transparent about. The FCA and those working in financial and prudential regulated areas, they have various duties towards consumers, but they're much more paternalistic. And what I mean by that is, it's not really about giving the information warts and all to your end user. It's much more about you deciding what information they need to have, you deciding to give them the information they need for their best interests in a way. And it focuses much more around that side of things. So it's not that full transparency that we talk about here. Legal accountancy, talk about broader principles of integrity, and I think most solicitors would say, wouldn't we, that we would be transparent with our clients, but it's not as prescriptive, it's not as proactive in some ways as it is in the health sector. And then on consumer protection, again, there's the focus on the end result. So is the end result fair to the customer, fair to the end user, rather than that, again, that kind of upfront transparency. So it really is, I think, unique. And in terms, it breaks down, I suppose, into three parts for me for the health sector. The first is the statutory duties that are enforced by the Care Quality Commission, and that's on providers and registered managers. Then there's professional duties, which are enforced on individual clinicians and professionals, mainly the GMC, NMC, HCPC. And then there are contractual duties, which in this sector, in part because they form part of the NHS standing contract and therefore are applicable to such a broad range of services that they become almost akin to sort of regulatory requirements really, in this context. So, what about providers? I should say providers and registered managers. This is something that quite often gets missed in terms of the duty of candour, is that it actually applies to registered managers of care services regulated by the CQC as well as the providers themselves. And again, much of the focus when we talk about duty of candour is on that relating to notifiable safety incidents, which effectively, it depends on whether you're an NHS provider or a non-NHS provider, but it relates to pretty much all incidents that cause harm or would have caused harms bar a particular intervention taking place. But there is actually also a general duty under the regulations to act in an open and transparent way. And the CQC will enforce that through inspections, potentially even through enforcement action on a non-criminal side of things. But I think part of the reason why there is such a focus on the specific duty on notifiable safety incidents is because it comes with potential criminal penalties, and because it is much more statistically measurable, and therefore it tends to get a fair bit of focus in terms of reporting and in CQC inspection reports as well. It is mirrored by a reporting duty to the CQC, particularly for non-NHS providers. But it is separate to that, and that is really where it stands out from other duties to make apologies, things like that as well. It does include the requirement to make an apology, and that's defined as an expression of sorrow or regret. And I think that to a certain degree, the reference to the word apology is sometimes what causes some issues on both sides of things, which is sometimes I think you get professionals who feel that perhaps they weren't liable or negligent or responsible for something, and feel that somehow making an apology implies that they are. And then on the flip side of things, I think sometimes when families and those involved hear that they should be receiving an apology, and that is not in fact an admission of having caused something or a admission of guilt or something like that, then it falls short sometimes of their expectations. So I think the phraseology around apology and what perhaps some people understand it to mean versus what it means in the legislation can throw up some of the issues that we see with the duty. There are contractual duties, as I said, under the NHS standard contracts. It's replicated in a lot of commissioner contracts as well, and effectively that mirrors the CQC statutory duties, both in terms of the notifiable safety incidents, but also in terms of the general duty to act in an open, transparent way. I thought I would also mention in this context the consumer protection. Now, consumer protection and the need, as I say, not to mislead and to look after the best interests of consumers applies across a broad sector. It's not specifically in the health sector, but if we look at how it is applied, getting ahead of myself, we're looking how it's applied, particularly when in the CMA's guidance, for example, on care homes, because of the way health services are organised, because of the extent to which once people are in a health service, they're in a pathway, it's very hard for them to move away from that. The level of expectation in terms of openness, transparency, giving full information really is very high in terms of, say, the CMA's expectations, particularly in terms of its application to that. So I thought that it's interesting to bring that in and to kind of see that really across the piece, wherever these kind of duties come in, where it applies in the healthcare sector, it does tend to be given sort of a greater emphasis in terms of the level of transparency. After that, moving away from the organisations and the registered managers, there are the separate duties for regulated professions. As I've said, primarily that's nurses and midwives in the NMC and doctors under the GMC regulations. They've effectively adopted the same guidance and approach in relation to the duty of candour, which is, as we put up there, it's about full openness, about all aspects of care and treatment, including where mistakes or harm have taken place. And the HCPC has quite a similar one relating to other regulated professions about open honesty and candour when something has gone wrong. These do not focus solely on where harm has been caused. Like the general duty advised by the CQC, they extend, and the guidance that sits underneath these makes it very clear that this extends to near misses where there's no harm caused, for example. So it's not necessary for professionals and those advising professionals to focus in the way that sometimes becomes a bit of a distraction when looking at notifiable safety incidents on whether a particular type of harm or whether harm is caused, whether causation can be established, because those duties of candour go beyond that. in these scenarios. There are also fit and proper person tests in relation to both employees of CQC regulated providers and also to directors of those kind of providers. And if you look within the guidance of that, it's clear that there is an expectation, perhaps not to the extent of the full candour that's described here, but certainly intent in case of any even reckless or sort of negligent misleading, and people can call into doubt that fit and proper person status in relation to that. So there really is quite a lot that touches on the individual side of things as well, and arguably goes even further really than the duty on the organisations, in particular, as I say, in terms of no harm incidents as well. I wanted to look a little bit, from my experience, what some of the barriers are to the effective implementation of the duty of candour in some of the providers and trusts that I've worked with. I should say what I haven't put up alongside here, it doesn't really apply to NHS, but there can be a bit of a lack of awareness among staff in some of the independent services that I work with, particularly where services might have a larger turnover of staff. In some of the domiciliary care clients we work with and some of the residential care homes, there's a lack of awareness and sometimes a lack of reporting that means that these things happen. But going beyond that kind of slightly more practical and training side of things, the issues quite often arise in terms of implementation where later down in a process, be it litigation, be it an inquest, it becomes obvious that there has been a notifiable safety incident that's occurred, or an incident that might trigger one of the other duties of candour. And there is quite often quite a real concern and uncertainty amongst those who are dealing with those kind of processes, particularly from the client side, on how they should deal with that. The reality is that duty still applies exactly as it does in as if you discover the incident at the time. And it is really important that people understand that. I've been involved in a number of patient recall exercises alongside different providers, both independent and NHS trusts, and it's a really important consideration in those kind of things. It can even arise alongside criminal investigations, and then complying with the duty of candour can be really quite complicated because there are all types of coordination, for example, the police, on what information you can put out there without impeding a investigation that's being carried on or potentially impacting on court proceedings in certain circumstances where something comes up much closer to the time. There's been quite a lot of work on trying to break down some of these barriers, and led really by NHS resolution, but also by others, which really emphasises what saying sorry is and isn't. So it's what it's aimed for, taking action to put things right, as it said, and that it is morally the right thing to do and doesn't amount to admission liability. I know that there was a time, and I hope this is long gone now, where providers were concerned that they might, in some way get in trouble with NHS resolution by making admissions of liability they shouldn't have been made during duty of candour. I think that's been thoroughly dismissed now, really, and NHS resolution have done a huge amount of work to do that. Outside of the NHS, I don't know whether that is quite as well known or quite as well understood in terms of private insurers and the interactions between the duty of candour and that kind of thing. So there's probably still some work to do there. I know that some of the insurers we work with are quite happy to refer to the NHS resolution guidance as representing their understanding of it as well. So hopefully that is getting out across the full sector. And of course, ultimately it is a duty. It's not limited by these different processes or by insurance terms or whatever else it might be. It is a legal duty. So, and it's a very important step, as I said there, in terms of learning from what happened. And that is hugely important, as well as the apology and the information. Knowing that the provider is taking steps is, in my experience, one of the most important things that those who have experienced poor care or their families are concerned about. Then there are some of the more practicality ones. I've already talked about lack of understanding by those, if I can put it this way, at the coalface, so those directly delivering care to service users or patients. I think because of the specific and sometimes quite complex nature of all the different parts of the statutory duty of candour in relation to notifiable incidents. Systems have sometimes grown up around it in organisations that are actually really quite complicated compared to what the aim of the duty is and the aim of the organisation is in trying to comply with that duty. That then feeds into a lack of time that, as we know, many clinicians have when they're conducting their work, and it can kind of combine together to give a feeling for those who perhaps haven't had it explained to them as well, that it's an unmanageable exercise to get on top of the duty of candour as a clinician. And in my work in the duty of candour working group, I have come across that as particularly when at some point in time the CQC expanded somewhat what it felt was within the definition of notifiable safety incidents, and then slightly reduced it back down again. But there was a lot of concern around that point that actually it was going to be far too much of an impractical drain on time. Now, in part, that's all about education, because some of that concern was a misunderstanding of what would meet even the broader criteria. Some of it, frankly, was a misunderstanding of the extent that was required. And when we've been able to have conversations with groups, and I've done this as part of training in the past, which says, if something happens and someone ends up with a bad outcome, not the outcome they intended, go through the process of what you would do. You would talk to them about how that happened, you would talk to them about what you understood about why, you would say that you regretted the fact that they had had that. And what you soon realise is that that common practice that people are going through, just as part of their everyday understanding of their role, ticks a lot of the boxes in terms of the duty of candour. It is then about making sure that that is properly recorded and that the proper written notifications go out, etc. But if it's explained properly and systems and processes can be put in place, then often that can really help kind of simplify it for people and drive that kind of compliance through as well. I think this dovetails with, there's sometimes a bit of an over-focus on the limits of duties over the real reason we got it in place in the first place. The group that I sit on has a patient representative on it, and they are incredibly helpful in terms of sometimes breaking down some of this, in saying, if we've spent 45 minutes arguing about whether this thing does or does not cross this particular little imaginary line in terms of the statutory duty, should you not be just communicating it to patients in any event? Because I think they would want to know. And, we can all, I have written articles and given advices on the exact extent and limits of these advice, so I'm as guilty as absolutely anybody in this. But sometimes it's needing to bring policies and documents and training back to the principles behind it, which is, why is it that there is a benefit from duty of candour? That is, you are looking after your patients better. You will feel better in performing your role. And I know that there is a perception that it reduces complaints. It reduces claims even in certain circumstances. So it's bringing back to those reasons behind it rather than that kind of focus on the black letter and the technical sides of it that could, I think, help implementation of all of these types of things. And as I said, it's that lack of focus on the benefits, really. We focus on the compliance rate. We focus sometimes on the reputational impacts and things like that, but actually it is those kind of broader, more principled things that are really the main benefits of the duty of candour when it's done properly.